start to the session. We're just going to give a few minutes while we wait for everybody to join. You can see the numbers climbing nicely. We're just going to give it a few more seconds and then we'll get started.
You see, the reason we do 1 to 2 is because the busy practitioners use their lunchtime for these things. But in Cape Town, lunch is from 2 to 4. I should know, I go there a lot.
Okay, it looks like the numbers have stabilized a little bit, so we can get started. Welcome, everybody, and thank you for joining us this afternoon. My name is Yoshini. I am your host for today's session, and we're really excited for this insightful session with Advocate Hussain. But I think before we dive into the discussion, I'm just going to give you a little bit of background and introduction to Advocate Hussain. He is basically part of the LexisNexis family. He's got a wealth of experience in the legal field, as most of you would know, and he brings a very unique perspective to our conversation today. His expertise and insights are undoubtedly something that will shed a very crucial light on the topic that we're about to explore. So let me just set a little bit of the stage for what's going to be coming up in today's session. We're going to be unpacking the art of gathering accurate information from your clients while ensuring that the questions that you ask remain unbiased. And I think in the legal field, that is a skill that is of paramount importance. It forms the foundation for effective communication. It helps us serve our clients better, and it just helps us get the job done. So without further ado, here's Advocate Hussain. Just one last note that before we start, there is a Q&A section, so you can log any questions that you've got. We'll try to get to them during the session or respond to you in the chat. But yeah, please use this as an opportunity to engage, ask any questions that are on your mind, and we'll try and assist as far as we can. So Advocate Hussain, over to you.
All right, thank you, and welcome everyone to this webinar. What we intend to do is present a series of very short webinars, 1 hour, 1 hour, 15 minutes, dealing with various aspects of litigation. We'll be dealing with civil litigation and not criminal litigation. The whole purpose is to focus attorneys on the concept that litigation is no longer seen as an adversarial contest between plaintiff and defendant or applicant and respondent. The problem in this country, as was in most other countries, the whole of the Commonwealth countries, the United States, litigation became too adversarial. In other words, the parties were like a pair of fighters in a ring, each trying to knock the other out. But what's happened since about the year 2000, after the Wolf Commission in England published its findings in 1999, the whole attitude towards litigation has changed. The problem with being over adversarial results in long delays and lengthy delays and costs. It's become too expensive. It takes too long. Something's wrong. And it will come as no surprise to you that the real culprits were the lawyers. It took too long and it cost too much because of the lawyers. It's not the clients who are really the adversarial animals. It's the lawyers who are the culprits. So let's see how we change this. The attitude towards litigation is that you go to court because there's a dispute. And we want that the parties to that dispute want it to be resolved as soon as possible and as cheaply as possible. Now, what we've done is we've even refined that concept. When we say where parties have a dispute, we mean that the parties have a genuine dispute. In the past, and even right now as we speak, people go to court just because they can. You can go to an attorney and ask an attorney to issue the summons or an application, and they'll do so. Now we say, go to court only if you have a genuine dispute that requires a judge to resolve it. So what we've done a number of things recently. One of the things we did is to begin pointing fingers at the lawyers. If a lawyer comes to court now with a case that has no merits, the attitude of the judges is that, listen, you're an officer of the court. You must have known that this thing has no merits. Why are you here? Well, the stock answer used to be, well, my lord, those were my instructions. Well, trust me, judges don't fall for that anymore. I know of a case recently where the judge looked at the advocate and said, look here, I know you have instructions, but you're an officer of the court. Surely that takes precedence. You cannot abuse the processes of the court just because you can or just because your client says so. So the whole idea is changing towards lawyers becoming more cooperative, less adversarial. Now that's the first thing you must learn. I know many of you attending this webinar are young people. Okay, the older lawyers, like people like me, it's very difficult to stop being adversarial. It's the way we grew up. The world has changed. If you look at our uniform rules, we recently introduced Rule 41A. The whole purpose of that is to force the lawyers to go and talk to the other side, possibly settle the matter before it goes anywhere. Most of you know that in terms of Rule 41A, you have to now, you have to send out a notice, whether you're plaintiff or applicant, to the other side, inviting them to possibly discuss settlement or resolve the matter through other means like mediation, discussion, and so on. There is a very significant development which you have to be careful of. Some of you may have attended my webinar on the hopeless case, where I pointed out that our courts are beginning to punish the lawyers for coming to court with a case that has no merit. Now, there's a very recent decision. It's called Sotrikwa versus the University of South Africa. Go and Google it. You'll find it on Safli. It's a labor court judgment where the judge found that the case was so devoid of merits that the applicant's lawyers, advocates, and attorneys were punished with a cost order. That's the last thing you want to do. So let's talk a little bit about how you start litigation, because things go wrong at the beginning because you don't do the basics right. Now, you can test this. Go to court, go to the High Court or the Magistrates Court, go to the Regional Court, and see what happens to civil cases that are on the roll for the first time. You will find that as much as 9 out of 10 of them get postponed. So now you wonder why, after it took maybe 3 years to get to that point, it then gets postponed and someone tenders costs and the parties go away. Well, there are a number of reasons why that happens. But one of the main reasons is that the lawyers start preparing for trial about the week before the hearing date. Well, it's too late. It's far too late. Then they discover, oops, our pleadings don't match the evidence that we have. The pleadings are saying one thing, the evidence is supporting a different cause of action. What that means is they have to amend. That means they have to postpone. And so it goes on, and it's not on anymore. So the object of these series is to provide practical guidance on how to resolve disputes in the best interests of the client. So I'm going to take you through 10 practical steps. But before I go there, there's something that tends to be ignored by the profession. The Legal Practice Council has published norms and standards. I would like to invite you to go and read those norms and standards. Those of you who are candidate attorneys or pupil advocates, you must read it because it tells you what the standards are for purposes of your PVT contracts. Now, it all begins with the first consultation. Now, do not underestimate this. This is not some mechanical process whereby you take instructions and open a file. It's more than that. Look, there are the formal requirements that you must comply with, things like your FICA compliance and so on. You, as attorneys, you know that you have to do that. If you're a Section 34 advocate, you know that there's these compliance requirements. I'm not going to worry you with that now. What I want to talk to you about is technique. Now, these days, you don't always consult in person. I may sound old-fashioned and say that in-person consultations are the most effective. However, many people have got used to the idea of consulting on the internet. You have a Teams meeting and most of the work can get done. So use the convenience of the internet, especially where you have clients from out of town. They don't have to fly in, or you don't have to fly over to them. But if you do consult in person, you must have a dedicated consulting room. The idea is for you not to consult where you work. I mean, you've all seen attorneys and advocates' offices. I mean, it's chaos, okay? You can't see the chaos behind me, but if I turn my camera that way, it looks like an old antique shop. So we tend to be a bit messy. So have a dedicated room. A good idea is to have a centrally mounted monitor so that you can bring up documents without having to make photocopies and so on. You will have all your files available electronically, and it's easier to consult that way. Now, a good habit is for you to find out before you arrange the consultation what the matter is about. A simple question to client when they call to make an appointment, you say, what's the matter about? Just tell me. They'll tell you, oh, it's a problem with a contract we have, or I've been sued for damages, or they'll tell you that this is a administrative problem. I want to review a decision of a local municipality. So they'll tell you what it's about. There's a good reason why I say you should ask your clients what the matter is about. You see, you are not a person who knows everything. No lawyer does. I mean, look, the law is vast. Your client might have a problem in an area that you don't really have much expertise. It's something new to you. Say the client says to you, well, I've received a notice from the Competition Commission. They are saying that myself and several other companies have been price fixing. Now you don't do competition work all the time. what you have to do now is go and read up. So what you want to do when you ask the question, what's it about? You are actually contextualizing the problem. What area of the law? Is it tax? Oh, that's something I know a lot about. So I'm not going to be too worried. It's copyright, or it's patents, it's medical negligence. Okay, that you may not be familiar with the area of the law. So, good lawyer, what you do is you go and read up. Read the basic textbook that tells you the general principles, and then go and find the most recent cases of the highest court. See if you can find constitutional law judgments around this area and read them. When you consult, you will have a working knowledge of the law. What this does, it makes you more confident in the consultation, and client is impressed that you are a person who knows what you're talking about. You don't sound confused, you're asking the right questions, and so on. Now, we'll come to the to questions, but how on earth are you going to ask your client questions in order to bring out relevant facts if you're not familiar with the area of the law that you're dealing with? All that will happen is that you'll take instructions in a mechanical fashion, and then you'll find that you'll have to call client back. Okay. So the best place to find the law is in primary sources. In other words, legislation and the case law. We in this country are a common law jurisdiction. We don't have codes like, say, the European Union has. Some of our law is codified, such as tax and company law. But our law is what the courts say is the law. Therefore, you need to look for the most recent cases. Now, here's a tip for you. As a lawyer in dispute resolution, you must learn how to use electronic law reports. And very importantly, you must learn how to use annotations. Annotations represent the history of a judgment. It tells you where it was applied. It tells you where it was referred. It will tell you if a higher court accepted the findings. And most importantly, it will also tell you if the case was set aside. So it's absolutely vital for a practicing lawyer to learn how to use annotations. Now, the reason I say that is because practicing lawyers, it's all about time and money. You can't spend an enormous amount of time on research while you go this hit and miss kind of research that you end up doing without using annotations. You'll spend a lot of time and client won't pay for those hours. So you'll run at a loss. Learn how to use annotations. Okay. Now, as a practicing lawyer, what matters the most are the facts. You are now practicing as a lawyer. You are no longer an academic lawyer. At university, you studied law to learn about the law. In practice, you use the law to find answers to a problem. So your client comes to you and expects you to solve the problem or resolve a dispute. And they want you to resolve it quickly and cheaply. Now, you cannot possibly be of assistance to your client if you don't know all the facts. For a practicing lawyer, the facts come first, not the law. That's a mistake that people make. It's the facts that come first. When you draft papers, particulars of claim, or a founding affidavit, or an answering affidavit, or a plea. It's the facts that give you a cause of action or a defense. It's not the law, okay? So if you don't know all the facts, and you start off by the way a lot of attorneys do, they get a rudimentary knowledge of what it is about. Client is very keen to litigate. They want to sue the other side. And you want to play along and you say, don't worry, I'll serve the summons on him tomorrow. I'll send the sheriff out immediately. Now the client thinks you're a hotshot lawyer. Well, you're not. You're going to get into trouble. You'll get your client into trouble. Unless it's an absolutely urgent matter, you sit down calmly and get all the facts. Now, my colleagues laugh at me when I say to them, listening is a skill, and lawyers are not very good at this skill. You must learn to listen to your client. It is their problem, not your problem. You have to, that's where you get the facts. Your client will give you the facts. You have to talk to client, make eye contact with client. You must be interested in what your client is saying. Oh, of course, it may be something you've heard before. If you've been in practice for many, many years, there's hardly a case that you haven't seen yet. So it's so easy for you to look bored or distracted. Big mistake. Clients notice it. They don't like it that you appear to be disinterested, distracted. They want to be assured that you are listening carefully and trying to understand what their problem is. I find that it's better to sit and engage with client without writing notes. First, hear the whole story. Only then do you write a statement. Because then you will write your statement including only relevant facts, and you will write the statement in a chronological sequence. That's very important. So there's a concept that you must understand that will make you a good lawyer. The one is listening actively. Secondly, reading actively. What does that mean? It means that while you're listening, you are applying your mind to the content of what is being told to you. When you read something, never as a lawyer read passively. If you read passively, it means that you are simply grazing through the page and you're not really following what the point is. And we all do it. I mean, everybody does it. I often find myself on page 3, and then I stop and think, but what's the point? And I can't remember what's on page 1. So I've been reading passively. You could read 10 pages passively and know nothing afterwards. It's because you're not applying your mind to what you're reading. When you are not reading actively, if you are not listening actively, you are kidding yourself. You are wasting your time. You are not going to be effective as a lawyer. So you have to concentrate on what your client says. If you are given reading material, read it actively. What is this? What is this saying? Do I understand it? What is the point being made? Can I write that point down? Now, that's an excellent way to test yourself, is to write the point down. And I find that many lawyers would read, say, a judgment, a chapter of a judgment, and they'll think, I get it. I see the point. Just wait until the lawyer has to now write it down. And then they struggle to write it. They were convinced they've seen the point, but now they can't write it down in their own words. So what happens? They've got to read again. If you're not listening actively or reading actively, you are wasting time and money, because you're going to do the same work again and again until you eventually get it right. So when you listen, the whole idea is to work out what happened. What happened between your client and whoever is creating the dispute on the other side. What client will give you is his or her version of what actually happened. Always remember, as a lawyer, keep thinking if there's scope for a possible settlement. Now, we never did that in the past, but now there's a rule 41A, that forces you to apply your mind to that very point. Is this capable of being settled? Now, I know you've got a client that might come in who's feeling very belligerent and wants to show the other side and to take him to court and so on. Well, I can tell you from more than 4 decades of experience that all the belligerence fades as you get closer to the doors of the court. Suddenly the fight goes out. The weird thing is that if you were not so belligerent, you could have settled the matter 2 years ago, but now you're at the doors of the court and now you want to settle it. It doesn't work. You just wasted money. But also, I told you, our courts have refined this thing to a point where we are compelling lawyers to become less adversarial. These days, if you go to court and you settle at the door, you'll get into trouble if you can't explain why. A judge will say, oh, very well, you settled it. Why didn't you settle it at the pre-trial conference 5 weeks ago? Why did you settle it here today? If you can't explain, the judge will just disallow your costs for the day, disallow you preparation costs, and you are going to be embarrassed, okay? When I say you listen to your client actively, it also means 2 things. One, you are looking for relevance. Clients have a habit of saying more than they should. Many clients, as you know, come to you, they've got a problem, but they would also like you to hear their whole history, about how they struggled through school and had to walk uphill both ways in the cold and the frost and all the sad stories, and you want to get to the point. You'll have to guide your client. Listen, that may not be the point. That's not really relevant. We can talk about that some other time. Keep the client relevant, otherwise you'll waste a lot of time. Active listening also means that you are keeping your eye on documentation. Now, as a lawyer, you know that to prove your case, especially in the civil courts, commercial cases, documentation is crucial, absolutely crucial. You win your case or you lose your case on the documents. So a good lawyer will make a note on the side that these are the documents that should be there. Clients don't often anticipate what documents the lawyer will need, so they bring in some documents and leave out others. Some of them turn up with no documents. So documentation is important. You should also now already be applying your mind to proof of the facts. Now, your client gives you a version. That version is useless if you can't prove the material facts. So what are you thinking? You're thinking there has to be witnesses. Who are the witnesses? Can we identify them now? Do they still exist? Can we find them? Can we get statements from them? That's what a good lawyer is doing. Now, the importance of listening to your client and getting the facts is that is what helps you to work out your case concept or the theory of your case. So you actively consider client's version of what happened. Theory of case or case concept simply means the facts according to your client's version of what happened. You need to know that. You will prepare your cause of action based on that. You will prepare your defense based on those facts. So they're vital. If you don't know the case concept, you will be misdirected in your drafting. I don't know any lawyer who can draft either particulars of claim or affidavits, pleadings or affidavits, effectively without having a case concept. You know, you stand up in court on day one of the trial and you're making an opening statement. The judge will want to know, hey, tell me what happened. What caused the trouble? What do you say is your case? You need to know that, because very often the pleadings don't tell the judge anything. When you're listening to client, confine yourself to the relevant facts. There's a dispute. If your client gives you a set of facts that are not relevant to the dispute, well, put that aside. A good lawyer, when a client says, this is what happened, work out what is it that you will have to prove in a trial. I know the trial is very far from your mind right now. You haven't even issued the summons yet. But trust me, now is the time to work it out. How will I prove those facts? Who will be the witnesses? What documents will I need? Already start making a note of that. And then there's a test which all lawyers must apply. You cannot hear your client's version and then go with it because those are your instructions. It doesn't work anymore. You'll get into trouble. What you need to work out as a lawyer, is that version likely to have happened? If your client gives you a version that is implausible, improbable, never go to court with a version like that. You are going to lose the case for sure. If you find that your client's version is improbable, a judge will definitely find it to be improbable, and you are going to get into trouble. A judge will say to you, but you can see this is nonsense. Why are you here in court? Now, if you say, those are my instructions, my lord, his lordship will meet you with a nice cost order. Okay. Now, here's a set of questions that I want you to consider. Can you answer these questions? What happened according to your client's version of the facts? At the end of the consultation, you should be able to answer that question. What are the issues? There will be factual issues, and there will be legal issues, and mostly a combination of the two that emerge from the facts. What are you going to tell the judge at the hearing? The judge tells you, listen, what is this case about? Can you tell the judge? What version are you going to present in your papers? That's crucial, because what lawyers don't seem to understand is that when you draft papers, pleadings, or affidavits, what you are saying in there is that here's my cause of action. It is based on this version of what my client says. Now, you see, for years, we got away with very poor drafting. What lawyers did is that they heard from client, oh, it's about contract, or it's a landlord and tenant matter. That's not a problem. They go pull out a precedent. They get a precedent. And they draft papers according to the precedent. Obviously, then, the papers say nothing about the version of your client. It's written in general terms that you get out of a precedent. That's discouraged now. What judges want to do is when they read your particulars of claim, they need to know what happened. They want to read the peculiar facts of your client's version must emerge from the papers. That is being enforced now. You can't plead vaguely. I mean, you plead out of a precedent as the plaintiff, and then the defendant files a bare denial. You know, the usual, the allegations are denied as if specifically Traverse and plaintiff is put to the proof thereof. That's what you see everywhere. Tells the judge nothing. You have no assistance, okay? How will you present evidence? It's all very well to think, I've got a good case here, but you'll have to prove it. What if your opponent challenges all your material facts? How are you going to prove it? Who will be the witnesses and what documents will I need? You need to answer that. How will you run the case from pleadings to final argument? Now, this process of reasoning has to be applied before you issue any papers. Before you start drafting, you need to know this. In other words, master the facts before you draft papers. Now, one of the problems that are created by the lawyers themselves is how they perform in the consultation. Now, clearly, you have to ask questions. You have to ask questions to bring out facts. You have to ask questions to bring out relevant answers, okay? Your object is to hear all the facts from your client. The worst thing you can do as a lawyer, and trust me, we all do it. I mean, I've done it many times. I have to admit, we ask our clients leading questions. Leading questions are dangerous. When you're taking instructions from your client, never ask leading questions. Don't say to your client, oh, so Mr. Smith signed this document. Client never told you he signed it. Okay? Client had to say, Mr. Smith signed this, I was present and I saw it. Now, if you say, oh, Mr. Smith signed the document, that's a leading question. Now, let me tell you what the danger is. Remember, clients are lay people. They're not lawyers. So the client is thinking, oh, that's what my lawyer wants me to say, that Mr. Smith signed the papers. Okay, I'll agree with that. Because now the client is thinking, if I agree with my lawyer, I'll get a better outcome. Well, you see the damage you're doing. Under cross-examination, you're going to have a problem. Your client is going to contradict themselves. They'll contradict the pleadings. Now, always ask non-leading questions to bring out the facts. Ask open-ended questions. It's like in court. When you're leading your witness in chief, you don't ask leading questions. You ask questions to bring out the facts. You never, when you're cross-examining, you only ask leading questions because we're going to put the answer in the witness's mouth. That's what happens in consultation. When you're taking instructions, do not put words in your client's mouths. You will get the wrong version and you'll pay a price later. Now, here is the next thing. Once you've got all the facts, you've read the law, you're now in a position to decide, does client have a cause of action? Yes or no? What are the prospects of success, good or bad? Does your client have a defense to the plaintiff's claim? You can work that out from the facts given to you, the documents that you have consulted. So, one of the things you should do as a lawyer is carry out what we call a merits risk. In other words, look at the facts, read the law, and ask, what are the prospects of succeeding? Is this, at this early stage, it might be no more than you having to establish that you have a viable or a discernible cause of action that is supported by the facts and the law. You may need no more than that. You can't decide at this early stage that this is a winner. Oh no, okay? But what lawyers can do is see when they've got a loser. That you can do. This thing has got no chance. The version is improbable. The facts don't support any discernible cause of action. We can't go to court. Always advise clients about the risks. I'll say a little more about that in a moment. Always advise clients about the implications of Rule 41A. By the way, you have to do this. You have no choice. You have to do it. Because when you issue your summons or an action, you will have to file a notice in terms of 41A. Now, what this rule does is it makes it very clear that the lawyers are not supposed to merely comply. There has to be actual compliance, okay? So this business of creating a template and then sending it to the other side, and they send you an answer back, which is also from a template, what you are doing is you are merely complying with the rule. Now, judges know that that's what lawyers do. So now they're saying actual compliance. You are genuinely going to talk to the other side about the possibility of settling the matter, about the possibility of engaging a mediator. So take instructions on this. Advise clients that that's the rule, okay? Client will say, I don't want to talk to that swine. Okay, fine, you calm them down. I know you don't have to talk to them, I'll talk to them, but this is what the rules require, okay? And explain why the rule is there. Managing client expectations is part of this exercise. You know, it's a bad lawyer who says to client, don't worry, we'll show the other side. We'll win the case. We'll get a cost order. I'll sue the pants off him. You can't do that. You raise expectations, and if they don't come to be realized, client is going to feel hard done by and is going to blame you. So you need to do a merits risk on these facts, and having read the law. Can I succeed? Can I settle it? Will I possibly lose? Now, the first two answers mean that, well, we can issue the summons. But if the third one is the possible or probable result that you lose, then you don't litigate. And tell client why. Then there's also this thing called a cost-benefit exercise. Good lawyer, before they issue summons, will say to client, firstly, listen, if we win, can the defendant settle the judgment? Or are we going to end up with an empty judgment with a nulla bona return or something like that? Perhaps the defendant is a man of straw. You'll show client that they will spend all this money and end up with a judgment that can't be satisfied. Clients need to know that. And you have to tell them that in writing. You have to tell them that, look, we're not so sure that this defendant can satisfy this judgment. The risk is that we'll spend all these costs and get nothing out. Clients appreciate it. And if you don't tell them, when the nulla bona return comes, client will blame you. They'll say, you didn't tell us this could have happened. If you only told us, we might not have spent all this money. So be careful about that. Okay. So we're back to this problem, which every lawyer encounters. I mean, you can't tell me there's a lawyer who only gets winning instructions from clients. What if you come up, your view is that the client does not have a case? What do you do then? In other words, there are no merits. Not in a cause of action, not in a defense, no merits. As a lawyer, you know that the best route here is to settle the matter. Good lawyer will say to client, look here are the reasons why I don't think we can take this to a court. Why don't I call the other side and we can sit down over a coffee and we can discuss the matter and see if we can't settle it. That's what you do. It's also a good idea to explain to client why this is a hopeless case and why they should never go to court. They will understand that. You know, many clients will come to you and they want you to win. They'll give you a set of facts and it's rubbish. You know it. They know it. Make it clear to them. Now, this aspect is crucial. I told you documents can decide whether you win or lose. Documentary evidence is very important, simply because look at it from a judge's point of view. You know, a judge hears a version from a witness. The judge has to evaluate the witness, decide if he's going to accept the evidence or reject it. Then the judge has to make findings of fact, and then from those findings of fact, draw inferences. And that's how judges resolve the matter. What is of assistance to judges? If a witness gives evidence and says, I have a recordal of what happened, here's a document. Document number 5 in the bundle, my lord, take his lordship through it. Judges love it because here is an external, objective piece of evidence that the judge can rely on. That is why documentary evidence is so important. So advise client about the evidentiary value of documents. Tell them, this is why I need those documents. Go and find the originals and bring them to me. However, as you know, the world has moved on. Documents are no longer produced in manuscript or in a typewriter or any other form of manual production. Everything is produced electronically now, on a computer, on a cell phone, on a laptop, any device. You have to explain to client what electronic discovery means, explain how you're going to have to prove this in court, explain what metadata is and where they can find it, ask client to give you access to the metadata, to the hard drive, explain to client how you preserve an important document electronically, how that is discovered and then proved in court. This has to be prepared from the start. In fact, my advice to you is that you should talk to your regular clients. You know, it may be a small business or it may be a big corporate. It's a very good idea to talk to them about being litigation ready. What we mean by that is the company or the individual businessman must already have a proper protocol for the preservation of all electronic documentations. Where's the data held? Is it in the cloud? Is it on an external hard drive? How can we prevent the data from being manipulated or corrupted in some way? These are things that could give you problems with proof at a later stage. Absolutely crucial. Very good idea to have a discussion with your client about this. The bigger corporates already know this, and they take various steps to protect their data from being hacked or corrupted or manipulated in any way. As a lawyer, you need to know that, because when you go to court, you will be expected to prove this in court. And you must have that proof now already. You must know that you can prove these documents. You can base your claim on these documents. When you get to your first pre-trial conference, that's where you will produce the document. You'll produce the metadata. You'll hand it to your opponent and say, you've got the metadata. Now, I seek an admission. If they don't admit, you will say, well, give me a reason why you refuse to admit this document. Because I will have to prove this document in court. And if you don't challenge my proof, then I'm going to tell the judge that I gave you an opportunity to admit this document. You refused. Now, most lawyers know now that if you don't make an admission and your opponent is put to the proof, whether it's merely a fact or a document, doesn't matter. Under cross-examination, you say to the judge, my lord, I have no questions. The judge won't even wait for your opponent to say anything. The judge is going to look at you and say, listen, why did you not admit this fact? Why did we have to call the witness? They'll make a cost order. So where do we deal with all these things? Where do we reduce the scope of the dispute? We now do it in case management. The whole idea was to do this in a pre-trial conference, Rule 37. But we all know how useless that is. We made a template out of all the things we're supposed to ask in a pre-trial conference, and then we just simply wrote yes, no, and we filed it in court. Served absolutely no purpose. So now we have case management. Unfortunately, there's no uniform procedure. Every court in the country has their own process. What I would like to recommend, though, is for those of you who are outside Gauteng, get hold of the joint practice directives in Gauteng. There's one that was issued this month. It's very new. Get a copy of it. You can get it from your local LPC provincial office, or you can just go online to the Gauteng, either the provincial or local division, and you can download it from there. It's very useful to know. All of the techniques explained there will help you even if you're not practicing in this province. There are some procedures which obviously won't apply in your province, but then you look and see what the requirement is in your province. But I want to highlight is that tell your client what case management is. What does it entail? Explain that the parties are expected to cooperate with each other, and that if you don't cooperate, you may pick up a cost order. And tell client that you will participate in case management on their behalf. And even invite client to attend. You know, there's a debate going on in a number of countries where some are saying, well, the lawyers should attend to the case management and clients should be left out. There's another school of thought that says, no, clients should be there. Let them see what's going on. So, you know, it depends on whichever judge is dealing with the matter. I know some judges here are quite happy to have clients sitting on case management meetings or conferences. I haven't come across a judge yet who objected to client being in the room. Okay, so it brings up some transparency, and client can see what is going on. And of course, there's an advantage if you are it's your client. You won't have to stand the matter down to take instructions and so on. Client's right there, you can get instructions. So there are some advantages to that. But right up front, explain this to client. They need to know this. And a very important aspect, something we tend to overlook, is reporting back to client. What we call status conferences, where you talk to client and say, this is where we are with this case. Pleadings have closed. We expect a discovery affidavit. We're now going into a pretrial conference over the documents. Tell client what's going on. So your job is to explain to client how you intend to proceed with the case with the object of resolving the dispute quickly and cheaply. You see, litigation is no longer about an adversarial approach, nor is it about access to courts and lawyers and so on. Litigation is about how you resolve the dispute. That's what you need to understand as a lawyer. You want to retain your clients, this is how you do it. Now, I'm going to stop there. This is basically the first in these series of webinars. We will go into more details regarding, for example, formulating a cause of action, your pleadings, affidavits. How do you use the Plascon test when you're drafting, and so on. Now, LexisNexis has a product called Practical Guidance. Most people call it PG, Lexis PG. This is an online product, and it helps practitioners with practical instruction. It tells you what to do, how to do, it provides you with templates, it gives you the time frames, it refers you to the most recent decisions. It's a very useful thing to have. You can call anyone on Lexis, any one of the LexisNexis staff members, and they'll tell you how to get onto it. Then there are two books that I'm going to recommend. This one, which I'm sure many of you have, it's a very popular book. It's called Practical Drafting Skills. It is recommended by, it is prescribed by the Legal Practice Council. The other book that is also very popular and prescribed is this one. It's called Trial Advocacy, The Art of Persuasion. And it's also extremely practical book. It tells you what to do, how to do, when to do. It's really all the guide that you want. So if you have a combination of PG and these two books, and you have a set of, you must have a set of the uniform rules, but PG will take you to all of the rules that you use on a daily basis and tell you how to use it. And you should have a copy of the practice directives. There are two sets that you should have. The one is the Gauteng directives, even if you are practicing in KZN or the Free State or the Northern Cape even. And secondly, get the practice directives of the court where you are practicing. That is where you will, that is something you absolutely must have. Because if you don't comply with the practice directives in your division where you're issuing papers, you will end up experiencing delays and worse, cost orders. So these are the basic tools that you must have. And I told you, when you're researching law, use electronic law reports. I know they can be a bit expensive at the moment. If you're a young lawyer, for example, Jutastat costs around 14,000 Rand a year. So it's not cheap. But you can get electronic law reports on Safely, okay, or Lexis can provide you with their all South African law reports at a very good rate. It has a facility for using annotations. So those are the basic tools that you will need. So I want to finish today. My time is up, I see, by just encouraging you to do one thing as a lawyer. You must read a lot. Read the directives, read the rules, read the judgments. I don't know what it is, but I get called by attorneys and advocates all the time saying, listen, I've got a problem. What do you think about this? Then I'll say to them, did you read this judgment? Oh, no, I didn't. Well, bloody go and read it and then come back. Don't come back because you see the answer. Even worse, I get questions from colleagues. They will have a problem, and I'll say, did you read the act? Now, my God, if there's one thing you can't get an attorney to read is legislation. Listen, legislation is not the most exciting thing to read. It's as boring as they come. But it's your job. You have to read the legislation. That's where the answers are. And you have to read the judgments. That's where the solution is. So read a lot. And you know what? Read books. Read lots of books. There's a certain book I've been recommending lawyers to read because it's so clever. Go and get this book. It's called Think Again by Adam Grant. You can get it in at Exclusive Books. Have it. It's a multi-million bestseller. I thought this book was written for lawyers, and it has a whole lot about lawyers in there. So, and it's fun to read. So read that stuff. It's very good for you. Okay. Are there any, Yoshini, are there any questions?
Yes, Advocate Hussein, I'm just mindful of time, but we've got 3 very nice questions that have come through.
Okay, let's go one at a time.
The first one from Brian Pozwa, who's asked actually 2 questions. The first is, could you please share the name of the labor court case that you mentioned pertaining to punitive costs again?
Yes.
And the second question, if you could please explain what case management is. Okay.
The case is Sotrikwa versus University of South Africa. If you just Google Sotrikwa versus University of South Africa labor court, it'll come up. Also, if you're interested in the subject of the hopeless case, there's an article that was written by Owen Rogers about it. There's also a chapter about that in this book. It's also based on Owen Rogers' article called about the hopeless case. Owen Rogers is a judge of the High Court. He's in the SCA. Excellent article. I suggest you read it. What is case management? Case management is a technique that's being used by our courts to manage the lawyers. It's got nothing to do with managing the case. Cases take too long. They keep getting postponed. And so costs go out of hand because the lawyers are the culprits. If you can control the lawyers, you'll control the case. So case management, if you're really interested in it, go and look up the report of the Wolf Commission. I've presented a number of lectures and webinars on case management. If there is a need, talk to the Lexis people. I can arrange a separate um, webinar on it. If you read the directives in your various courts, you will see there what case management is about. In this country, the cases are managed by the judges. In other countries like England, Canada, Australia, they have a case manager, a dedicated case manager in court, in the building, who does these things. Like they call the attorneys and advocates in at an early stage and say, look, pleadings have closed. By the way, plaintiff, your pleadings don't make sense. What's the cause of action? Or defendant, I see a bare denial here. Do you have a defense? So you're forced to deal with this very quickly. And I'll tell you why case management has been so effective around the world. If you take England, which took 3 to 6 years to finish cases, they are finishing their cases within 9 months. If you take Canada, they are excellent. I've actually been there to see how they do it. They finish any case in the High Court from issue of summons of process and to finality through judgment or settlement, 3 months. Can you imagine? Your case is done in 3 months. So this, throughout the world, there is case management being introduced into the courts. I mean, India is a very good example. It could take 20 years for a matter to finalize. Now, with case management, they do it in 10 years. That's how effective it is. It's working in this country too. You can get your case into court within a year. It's actually possible. So if you don't know enough about it, you cannot practice civil litigation if you don't know what case management is about and how it is practiced. Another question?
Next question is from Anonymous, asking, where do you get practice directives for regional courts? They're not online, only a general magistrate court practice directive.
Yeah. Go online and look for the practice directives issued by the presidents of the regional court. The regional court presidents issue a directive, and that's where you will find it. You won't find it in Jones and Buckle. Okay. Another question?
The last question from Pramod Mambod. He's asking, what is e-discovery?
It's electronic discovery. It's normal discovery, but not hard copy. It's discovery of documents that originate in an electronic device, like a computer, a cell phone, a tablet, laptop, whatever. Because unlike hard copy, if you take a contract that has a signature in ink in the normal way, that is far more easier to prove than an electronic document, because electronic documents are more susceptible to manipulation, interference, corruption, and things like that. So we have electronic electronic discovery, which is done exactly in the same way, and it's done exactly the same way and as the ordinary documents, but the proof of those documents is very different. So we call that e-discovery. There are a whole set of rules and jargon and so on. I want to show you another book, which is also a LexisNexis book. It's called E-Discovery, A Guide to E-Discovery in South Africa. So go to Lexis. This book is available. Okay. Right. Any more questions, Yosheni?
Just 3 questions. Thank you, Advocate.
Oh, that's it. Okay.
Yeah, and I think we can start wrapping up now. So thank you so much, Advocate Hussein, for a
Okay.
very insightful session today.
Okay.
And
Okay.
thank you to our delegates for participation and your presence this afternoon. If you guys have found today's session as enlightening as I have, you'll be pleased to know that we do have a few more sessions lined up. So you can keep an eye out on your emails for invitations and updates on what's coming up next in our series. Yeah, again, thank you so much for your time. And until the next session, take care.
All right. Thank you. Bye.
Bye.